Tonight at 6, an Ohio double murder suspect is garnering attention here in the state line.
39-year-old Michael McKee was arrested Saturday here in Rockford. He's accused of killing his ex-wife and her husband. Just hours ago, he made his first court appearance in Winnebago County. Our Elizabeth Ippolito joins us now live outside the courthouse. Elizabeth, what can you tell us?
Mimi, Wendell, Michael McKee has an active medical license here in Illinois and was listed as a vascular surgeon with OSF, including in Rockford and Ottawa. The hospital group telling us in a statement OSF is cooperating with authorities who will provide any further information. Meantime, McKee faced a judge for the first time today inside a Winnebago County courtroom. The 39-year-old was arrested in Rockford on Saturday and today electing not to fight extradition back to Ohio, where he's charged with 2 counts of murder after his ex-wife and her husband were found dead.
What does it take for a prosecutor to upgrade murder charges to premeditated aggravated murder? What evidence convinces them that someone didn't just kill in a moment of rage, but planned it, calculated it, designed it with cold precision? In Illinois, a vascular surgeon sits in a jail cell wearing a mustard yellow jumpsuit, charged with exactly that kind of killing. His alleged victims, his ex-wife and her husband, executed in their home while their baby slept down the hall. But here's what should make every viewer lean forward. He just stood before a judge and waived his right to fight going back to Ohio. He's requesting a speedy return to face trial. And his attorney says he intends to plead not guilty to every single charge. So ask yourself this. If you were guilty of double murder, would you rush back to the state where you're facing potential death penalty charges? Or does Michael David McKee know something the prosecution doesn't? January 13th, 2026. A Winnebago County courtroom in Illinois. The hearing lasted minutes.
All in favor of Michael McKee?
Third order, the defendant is present in custody.
Your name, sir, for the record? Michael McKee. Have you had a chance to speak with him?
Yes, Your Honor.
What's your position at this time?
Yes. At this time, Your Honor, on behalf of Mr. McKee, I will assert his right to counsel. I will assert his right to remain silent. And Mr. McKee believes that the most expeditious manner in which he may defend himself against the charges pending in Ohio and to plead not guilty would be to waive his right to an extradition hearing and to have a governor's warrant and to agree to his immediate transportation to Ohio.
Understood. Thank you. We will set this matter then for 2 o'clock on Monday. Your status on the transfer.
Thank you.
Anything else we can do today?
Not from this one.
Thanks, everyone.
Michael McKee, 39 years old, shuffled in wearing shackles and that distinctive yellow prison uniform. He spoke only once during the entire proceeding, stating his full name when the judge asked. His court-appointed public defender, Carrie Poirier, did the talking. She told the judge her client understood his rights and was waiving his extradition hearing. More significantly, she made a statement that sent ripples through the legal community watching this case. McKee intends to plead not guilty, not just to the original murder charges, but to the upgraded charges of premeditated aggravated murder that now carry the possibility of life without parole or execution. Think about the legal strategy here. Prosecutors don't upgrade charges lightly. The Columbus Division of Police stated that detectives believed they met the elements required to charge McKee with aggravated murder with prior calculation and design. Under Ohio law, that's a specific legal standard. Murder requires proving someone purposely caused another person's death. Aggravated murder requires proving they planned it beforehand, that they calculated how to do it, that they designed the execution of another human being. The difference between those two charges can literally be the difference between eventual freedom and dying in prison. So what evidence do prosecutors have that makes them confident enough to pursue the higher charge? Let's examine the timeline that's been established through court documents and police affidavits. December 30th, 2024, between 2 and 5 in the morning, someone entered the Tepe home in Columbus, Ohio's Wineland Park neighborhood. No forced entry. No signs of struggle outside. This person knew how to get in, or was let in. Spencer Tepe, a 37-year-old dentist, and Monique Tepe, a 39-year-old mother, were both shot to death. 3 9mm shell casings were recovered from the scene. Their children, ages 4 and 1, were found unharmed but traumatized when friends discovered the bodies around 10 that morning after Spencer failed to show up for work. The prosecution's case appears to rest on several pillars. First, surveillance footage. Multiple neighborhood cameras capture a person of interest wearing light-colored pants and a dark hooded jacket walking through a snow-lined alley adjacent to the Tepe residence during that critical 3-hour window. Police tracked this individual's movements through various cameras and identified a vehicle. Court documents state that this suspect was tracked to a vehicle which arrived just prior to homicides and left shortly after. Here's where it gets damning for McKee. Investigators traced that vehicle to Rockford, Illinois, and confirmed McKee was in possession of it both before and after murders. When McKee was arrested on January 10th, he had access to that same vehicle. But Columbus police have been careful about one crucial detail. When asked directly whether McKee is the person visible in that surveillance footage walking through the alley, they declined to answer, stating they didn't want to compromise the case. Why the caution? Because definitively placing McKee at the scene versus placing his vehicle near the scene are two different evidentiary standards. The prosecution knows that, the defense knows that, and now, as McKee prepares to plead not guilty, that distinction becomes critical. The relationship history adds layers to the prosecution's theory of premeditation. McKee married Monique Tepe in August 2015 when she was 28. Their marriage lasted less than 2 years. Monique filed for divorce in June 2017 on grounds of incompatibility. The divorce was finalized within a month. Court records show no major conflicts during proceedings. No children together. No spousal support awarded. McKee got their Virginia home. Monique was living in Westerville, Ohio. By all appearances, a clean break. McKee continued his medical career, working his way up to becoming a vascular surgeon. Monique moved on, met Spencer online, and married him in December 2020. They built what everyone described as a beautiful, strong, deeply happy relationship. They had 2 children. They were 1 month from their 5th anniversary. 8 years passed between the divorce and these murders. 8 years. That timeline is crucial for the prosecution's premeditation argument. Criminal defense attorney Joey Jackson, analyzing this case, noted that once discovery begins, investigators will scour McKee's social media history, internet searches, phone records, and movements. They'll be looking to establish whether he was surveilling Monique, whether he'd been in Columbus without anyone knowing, whether his digital footprint reveals obsession, planning, reconnaissance. Because proving premeditation isn't just about showing someone thought about killing for a few seconds before pulling the trigger. It's about demonstrating a calculated plan developed over time. The defense strategy is already taking shape. By requesting a speedy return to Ohio and announcing the not guilty plea, McKee's legal team is signaling confidence, or perhaps desperation. In criminal law, there are times when rushing to trial benefits the defense, particularly if they believe the prosecution's case holds. Ohio authorities now have 30 days from when McKee waived extradition to transport him to Franklin County. However, there's been a complication. As of January 14th, a court order revealed that McKee's transport to Ohio won't be feasible by the originally scheduled January 19th date. A new status hearing is set for January 23rd, meaning McKee remains in Winnebago County Jail longer than expected. Every day that passes is another day for both sides to prepare their cases. McKee hasn't been formally indicted yet. That can't happen until he's physically in Ohio. Right now, He faces charges based on a criminal complaint. Once he arrives in Franklin County, a grand jury will hear evidence and decide whether to indict. That's when we'll likely learn more details about what evidence prosecutors actually have. Grand jury proceedings are secret, but the indictment itself will reveal the specific allegations and legal theories the state is pursuing. Consider what the defense has to overcome. They need to explain why McKee's vehicle was in Columbus during the exact time frame of the murders. They need to account for his whereabouts during those critical hours between 2 and 5 in the morning. They need to address why, of all the nights in 8 years since the divorce, his vehicle appeared in that alley on the specific night Monique and Spencer were killed. They need to counter whatever digital evidence investigators find during discovery, and they need to do this while their client asserts complete innocence. The motive question looms large, but here's something critical that many people misunderstand about criminal trials. Prosecutors don't legally need to prove motive. They need to prove beyond reasonable doubt that the defendant committed the crime. Motive helps tell a compelling story to a jury. Helps make sense of why someone would do something so brutal, but it's not a required element of the offense. Still, juries are human. They want to understand why. And 8 years after a divorce that appeared amicable, the question of what could drive someone to this level of violence becomes psychologically crucial for both sides. Legal analysts watching this case point to several possible directions for the defense. They could argue misidentification, that McKee wasn't the person in that alley, that his vehicle was there, but he wasn't driving it. They could argue that while his vehicle was nearby, there's no physical evidence placing him inside the Tepe home. No fingerprints have been publicly mentioned. No DNA evidence has been disclosed. No murder weapon has been recovered. The shell casings tell us caliber, but not whose gun fired them. They could even argue that someone else had access to his vehicle, though that becomes harder to sustain if prosecutors can establish McKee's continuous possession of it. The upgraded charges to premeditated aggravated murder suggest prosecutors believe they have evidence of planning. What might that evidence be? Prosecutors typically look for things like pre-purchased weapons, reconnaissance visits to the location, internet searches about how to commit crimes or avoid detection, communications that suggest planning, changes in behavior or routine in the days before the offense, purchases of items used in the crime. Discovery will reveal whether any of these elements exist in McKee's case. There's another dimension to consider. McKee maintained a successful medical career throughout these 8 years. He saved lives as a vascular surgeon. His medical license shows no disciplinary history, no malpractice claims, no red flags whatsoever. His colleagues at OSF St. Anthony Medical Center in Rockford apparently had no concerns about him. A neighbor in his Chicago Lincoln Park high-rise building told reporters she'd chatted with him by the pool, found him pleasant and nice. She expressed shock that someone she casually socialized with could be accused of such violence.
How do you explain to a child that mom and dad are here one day and gone the next? Those are the real victims of this whole case here, are the children.
How does someone compartmentalize alleged planning and execution of a double murder while maintaining the demanding schedule and responsibilities of a surgeon? Or is the prosecution wrong about who committed these crimes? The courtroom where McKee will eventually face trial will become a battleground over what can be proven versus what can be explained away. Circumstantial evidence, when it accumulates, can be incredibly powerful. A vehicle at the scene, a history with the victim, opportunity, means. But circumstantial evidence can also leave reasonable doubt if even one element doesn't quite fit. The defense only needs to create reasonable doubt in the mind of one juror. The prosecution needs to convince all 12 beyond any reasonable doubt. As McKee sits in that Illinois jail cell awaiting transport to Ohio, both sides are preparing for legal warfare. Prosecutors are likely working with forensic specialists, timeline analysts, digital forensics experts, and behavioral psychologists to build their case. The defense is probably already filing motions, requesting discovery, preparing challenges to the admissibility of evidence, and developing alternative theories of the crime. When this case finally goes to trial, the jury will hear about surveillance footage, vehicle tracking, the relationship between McKee and Monique, 8 years of history, and ultimately, whether the state can prove beyond reasonable doubt that the surgeon planned and executed a double murder. The stakes couldn't be higher. If convicted of premeditated aggravated murder in Ohio, McKee faces either life in prison without the possibility of parole or potentially the death penalty. If acquitted, he walks free, though his medical career and reputation would likely never recover from these allegations. The legal system will now do what it's designed to do: test the evidence, challenge the theories, protect the rights of the accused while seeking justice for the victims. Spencer and Monique Tepe can't speak for themselves anymore. Their 2 children will grow up with relatives, processing a trauma that no therapy can fully heal. The legal proceedings ahead won't bring their parents back. But what happens in that Ohio courtroom will answer questions that matter. Can the prosecution prove their case? Did Michael McKee plan and execute these murders? Or is there reasonable doubt? This is Crime Lab Report, and this case is just beginning its journey through the legal system. The extradition hearing showed us McKee's strategy: get to Ohio fast, plead not guilty, and fight. But fighting requires more than just saying you didn't do it. It requires explaining away evidence, creating alternative scenarios, and convincing 12 people that the prosecution got it wrong. Over the coming months, as discovery unfolds and both sides reveal their evidence, we'll learn whether the state's case is as strong as the upgraded charges suggest, or whether McKee's defense team has identified weaknesses that could lead to acquittal. What do you think? Does requesting a speedy return to Ohio and immediately announcing a not guilty plea suggest innocence or just aggressive legal strategy? Can you explain why someone's vehicle would be at a murder scene during the exact time frame of the killings if they weren't involved? And here's the question that should trouble anyone who believes in the justice system. What if 8 years of apparent normalcy, a successful career, and no prior criminal history mean we're looking at the wrong person? Drop your analysis in the comments. Are you convinced by the evidence we know about so far? Or do you think there's reasonable doubt already visible in this case? Hit subscribe, because when this case goes to trial, when we finally see the full evidence presented in open court, you're going to want the detailed legal breakdown. And remember, in our system, Michael McKee is presumed innocent until proven guilty. The prosecution has to prove their case. The defense just has to raise doubt. We'll be watching every development as this case unfolds. For Crime Lab Report, I'm reminding you that the courtroom is where truth and law collide, and sometimes the verdict surprises everyone.